Hi, I'm George Whipple, one-on-one with Dov Lutzker. Dov, let's talk a little bit about your background. Where are you from and how'd you get here?
Most recently came here from the Department of Justice. I was there for 24 and a half years. I was in the Civil Rights Division in the Disability Rights section. So I've been enforcing the ADA at DOJ for, I think it's over 2/3 of the time that the ADA, which is a young law, was in effect. And now I'm happy to be at EBG.
Almost a quarter of a century at the DOJ. Now, how does that experience help our clients?
In two ways, really. I've got a plaintiff's perspective that I've had for a long time, and so that's a language that I speak, and I'm able to analyze cases from that perspective. And then also just being at DOJ, I was around the people who wrote the ADA. I was around the people who wrote the regulations, and I know how the DOJ operates. I also found that a lot of people get intimidated by investigations or litigation by the DOJ or the EEOC, and I think I can really help people work their way through that.
Listen, the pandemic changed everything. I think initially clients were afraid that if we gave an accommodation to one, we allowed one to work from home, everybody would be working from home. How do you advise clients about accommodations for working from home?
But what employers need to do is just run through a whole ADA analysis. Is the person a person with a disability? Because the ADA applies to people with disabilities. So I guess one of the questions is remote work something that a person wants, or is it a need based on a disability? The whole point of interactive process is to engage with the person and find out what their functional needs are and what kinds of accommodations the person really needs in order to perform the essential functions of their job.
Now, what is that interactive process? How does it apply to the ADA? How do employers do it correctly? How do they do it incorrectly?
Well, the interactive process really needs to be interactive. It's not just a one-way street where the employer's sort of dictating something to the employee. It's an opportunity to do an individual assessment and have a dialogue with the person to figure out what are their functional needs and relate those directly to the essential functions of that person's job, and also to figure out whether the accommodation is reasonable or not.
We're in a strange place now. The government is who's open, who's closed, who's funded, who's not funded. Is the threat today more from private plaintiffs in this space and less from the government? Or do you think we're going to see enforcement and litigation from both sides of the aisle, so to speak?
No, that's a good question. I was one of, I think, around 300,000 federal employees who left the government in 2025. And that's going to have a big impact. In the Department of Justice and the Civil Rights Division, 70 to 80% left. And at the EEOC, I think it's at least 22%. So there's not a lot of staffing there at the moment. And also the priorities have shifted. The priorities are not on sort of traditional civil rights laws enforcement. So that doesn't mean that employers are sort of off the hook and they don't need to worry. It just shifts where the litigation is coming from. And where it's going to come from is private plaintiffs. And all my former colleagues at the Department of Justice and EEOC are getting jobs at different organizations, and they're going to be very active in litigating cases. And they're also going to states, and I think states are going to pick that up as well. So I don't anticipate a lot of enforcement in the near future coming from the federal government, although I will say they're going to be hiring, and we're going to watch it closely and see if things change.
Thanks, Dov, for being here, sharing your insights from both the plaintiff side and the defendant side. And thank you very much for watching. I'm George Whipple.